Well, thank you.
Great. Great. Well, we are here on the sole case set for this morning, and welcome everyone to the First District Court of Appeals. So our case this morning is case number C200079, State of Ohio. Nope, C200164, State of Ohio versus James Reimer. If counsel can please identify themselves and their readiness to proceed.
Angela Glazer on behalf of Mr. Reimer, ready to proceed, Your Honor.
Good morning, Attorney Glazer.
Good morning.
Judy Lapp for the state, ready to proceed.
Good morning, Attorney Lapp.
Good morning.
I'm glad to see everyone healthy and well this morning. Attorney Glazer, would you like to reserve time?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal.
All right. Whenever you're ready.
Thank you, Judge. May it please the court, Ms. Lapp and Mr. Reimer, who I believe should be listening in this morning. Judge, I'd like to start with the issue of self-defense. The state has to prove beyond a reasonable doubt 3 elements, or that the defendant was not acting in self-defense beyond a reasonable doubt. And there's only 3 elements to the self-defense. And however, in the jury instruction in this case, the court instructed the jury that there was an additional element, the reasonable force, that if Mr. Reimer did not use reasonable force, if the state could prove that beyond a reasonable doubt, that was enough to negate the self-defense on his behalf. And by doing that, it essentially lowered the state's burden, because this isn't a question of they have to prove that he was not acting in self-defense and meet all 3 elements. They only have to meet that burden on 1. So by adding an additional element, it gave the state an opportunity or an out to just show that, well, if the force wasn't reasonable, then they've met their burden. And in this case, it was extremely important because Mr. Landaker was killed by a single gunshot, and Mr. Reimer was not injured. So by telling the jury, if you find any one of these elements, if you say the state has proven beyond a reasonable doubt that the force was not reasonable, you don't even have to look at the other elements. If you find on that element alone, then the self-defense is not available to Mr. Reimer, and that was his whole defense here in this case.
How is that not a correct statement of the law? I mean, the law requires in a self-defense case that the force be reasonable, right?
So, and Judge, I can elaborate on that. And if you look at some of the cases cited by the state in their brief, for example, State versus Gray out of the 2nd District, the court discusses that oftentimes the language of reasonable force is missing from that element's instruction itself, and that reasonable force is required in order to assert the self-defense altogether. However, the way it's discussed is that it's a component of the 2nd element. Reasonable force goes to that 2nd element. It's not an additional element. It's used for the jury to decide whether or not Mr. Reimer was acting with a bona fide belief that he was in imminent danger. And the cases only discuss reasonable force in those 2 contexts. They discuss it either for the jury's consideration under that 2nd element, or they discuss it in purposeful killings where self-defense would not be available at all as a defense. And the way that it's used, you can see in the transcript here in the jury instructions and in other cases that discuss the reasonable force definition, it's used following the element section. So, for example, in this case, in the jury instructions following the elements, the court goes in to define then excessive force. And under that, it states a person is allowed to use force reasonably necessary. It defines excessive force. If a defendant used more force than reasonably necessary, this is just disproportionate. And then it defines disproportionate. It defines reasonableness. And so it's not an element that the state can negate. It's actually just a definition for the jury to consider under the second element of whether he had a bona fide belief or not that he was in danger.
So whether his belief was reasonable in the second element, you're saying that the excessive force instruction goes to that?
Correct. And reasonableness is defined throughout the jury instructions. And it's used that way to explain the elements, not an additional element itself. So by creating, and there's no case law in all of the cases cited by the state, either whether you look at the preponderance of the evidence on behalf of the defendant when it was their burden, there's always the three elements. There's never a fourth element of reasonableness. It's only used in the context of definitions and understanding the elements or whether or not self-defense is available. And that's under the old burden and under the new burden for the state. At first glance, it seems like, well, you're requiring an additional element on the state here if you're adding a fourth element, but it actually works by lowering their burden, giving them another way to get out by just showing, hey, this wasn't reasonable. And here it made a difference in the outcome because, as I stated, Mr. Landaker, by a single gunshot, was rendered dead while Mr. Reimer suffered no injury. So if you say to the jury, was that force reasonable? No, it wasn't reasonable. The man's dead now. You don't even have to go to the other elements because it's an or, not and analysis.
But
And
it's always something the jury has to consider, right? I mean, that's always going to be something the jury has to look at, is whether the force was reasonable.
You're correct, Judge. It is always something the jury looks at. I would argue here the self-defense was all or nothing for Mr. Reimer. Proving something beyond a reasonable doubt is the highest burden that we recognize. And if you start with that premise for the jury instruction that if you find that it wasn't reasonable, that's enough right there, that the self-defense it's not even available to him at that point. And so that's why it was extremely important, in my opinion, in this case, because you start there. And if the jury is deliberating and they look at that one element, does anybody, raise your hand if anyone thinks that the force wasn't reasonable in this case? Self-defense isn't available because you got four elements. And that's why I think that it was most important in this context, because you're looking at a jury instruction where if you find that there's no other deliberation to be had or no other consideration to be made.
Can a jury find self-defense if they find that the force was unreasonable?
Yes. So if you look at the definition in the jury instructions for this case, for example, because obviously I'm not sure in other contexts how it would be defined. It talks about excessive force, and that you may consider whether the force used showed revenge or a criminal purpose. And it also talks about if the force is reasonably necessary to protect oneself from apparent danger, if the force was greatly disproportionate to the apparent danger. So I think the definitions, there is some movement for a jury to find that maybe the force exceeded what was necessary, but they could still find that under the second element, the defendant felt at that time that he needed to use the force because he was in imminent danger of great bodily harm. If there are no other questions as far as the first assignment, I would like to briefly address the second assignment of error. Whether the evidence supported the voluntary manslaughter instruction. And interestingly enough, in one of the cases, State versus Farrell cited by the state under the first assignment of error, in reviewing that case, there's a discussion for several paragraphs, specifically paragraph 38, discussing why evidence supporting self-defense does not support sudden passion or fit of rage, and why fear is in opposite to rage and doesn't support the voluntary manslaughter, because one's either in fear or one's in rage. And because Mr. Reimer was asserting the self-defense, and the evidence didn't support the voluntary manslaughter instruction, I argued that it should not have been given. But also, it ties into the third assignment of error under the ineffective argument as to why his counsel pursued the manslaughter conviction over his objection.
Well, how is it over his objection? I understand he rejected a plea, but the objection wasn't really made known at trial.
Well, Your Honor, before the trial started on transcripts, pages 2 to 4, his counsel specifically asked him, they said, we've been involved in negotiations with the state for a manslaughter plea, but Mr. Reimer never authorized us to enter into plea negotiations. Asked him flat out, would you like to consider a manslaughter? Mr. Reimer said no. Court asked him, he said no. At the close of evidence, again, the state put on the record that they still would consider a manslaughter offer. Mr. Reimer rejected that offer. Prior to the trial starting, his counsel cited a case out of the Supreme Court and stated it was Mr. Reimer's, and I believe this was on transcript page 3. Mr. Reimer it's his role in a case to decide whether or not to accept a plea, and that he had flatly rejected it and wanted them to pursue a self-defense strategy. And that is a defendant's option whether or not to accept a plea. However, he had rejected it before and after close of evidence, and then counsel then instructed the jury to find him guilty of the manslaughter, saying, wouldn't that bring on a sudden fit of rage? That's a manslaughter. The defendant's under passion or rage. That's manslaughter. So essentially saying convict him of manslaughter, and then doesn't object to the manslaughter instruction. And the court then tells the jury in the jury instructions, the defendant claims he acted under sudden passion or rage. This is immediately following Mr. Reimer stating to the court that he was not, that he did not want to accept the manslaughter plea. And that's something that he should decide and not counsel.
Where I'm getting stuck,
Yeah.
even if we would agree with you that the jury should not have received the instruction, how is he prejudiced in this case? Because they rejected his self-defense. He would have been convicted of murder otherwise. So it sounds like he benefited.
So, Judge, it's very powerful for a defense attorney to ask a jury or to tell a jury that the client is guilty of a manslaughter, and then for the instruction to say that the defendant acts like he was under a sudden fit of rage, or that he's claiming that this is his defense. So essentially, the instruction says, and the jury asked repeatedly for another copy of the instructions, but the instruction says that he's saying that he was under a fit of rage. I don't know how a jury gets around that. Once they say defendant claims he's acting or he did this under a sudden fit of rage, and then his counsel says this is a manslaughter. I mean, I think that it's powerful. The jury, if they had the option of, Mr. Reimer indicated that he was willing to go with the self-defense and he didn't want the manslaughter. So he was willing to either be convicted of murder or he was willing to be acquitted on self-defense grounds.
Ms. Glazer, let me ask you a question on that. I know that under State versus Wine, it's really no longer up to the defendant with the all or nothing defense. But this is my question concerning counsel. Isn't counsel sort of in the box when counsel knows the judge is going to give that instruction? I guess you could continue to argue that your client's not guilty, but there's really nothing counsel can do at that point other than continue to argue that your client is not guilty. Do you understand what I'm saying? I mean, it's not up to the defendant, it's not up to counsel, it's up to the court to determine whether to give the instruction on the lesser included offense.
I follow your logic, Judge, and it's a difficult decision that I'm sure defense attorneys face every day in trial. However, the jury instructions were given after closing argument, and by counsel arguing that his client was guilty of the manslaughter, it then gave more weight to giving the instruction. There was no objection given to giving the instruction. He actually argued for the instruction. So I think that carried some weight with the judge's decision to give the instruction, because it was argued by counsel in closing argument. There has to be enough evidence presented to support the instruction.
Okay,
So your basic, just so I understand your basic argument on this, the prejudice comes from the fact that counsel basically lessened the self-defense defense in this case by arguing to the jury sudden passion or fit of rage. It doesn't jive with the self-defense claim, and so kind of almost negates it.
Correct.
Okay.
And in the case law, I cited one case in my argument that just basically supports the fact that fear, which is the basis for self-defense, is distinguishable from rage, which is the basis of the mitigating factor in the voluntary manslaughter statute. The two are inopposite. And so by arguing that he was enraged at the time, it negated his ability to argue the self-defense.
Thank you for your argument. I'm going to reserve your 3 minutes.
Thank you, Judge.
Attorney Lapp, whenever you're ready.
On the first assignment of error, you also have to keep in mind during all of these arguments, the defendant has to show the outcome would clearly have been different. So even if that phrase that she's discussing about using reasonable force had not been in there, you cannot ever say that the outcome clearly would have been different. The appellant's not saying the instruction was legally incorrect, not saying that any of the case law stating a part of the definition of self-defense is that the force was reasonable. There's no argument that that is not correct. And there's no argument against the instruction on excessive force, which gets into the same issue that's being objected to. And that doesn't make sense because using reasonable force is a part of all of this. There's no question that's what the law is on self-defense. The jury instructions have to be a correct statement of law, and it must be pertinent, and they are to be tailored to the facts and circumstances of the specific case. And that's exactly what the judge did here. And frankly, the judge could have gone into more detail on these issues. A judge does not have to read OJI verbatim if they use it. A judge may paraphrase. The judge is going to explain legal terms and give definitions, and many times can give examples of things to explain.
Did this lessen the prosecution's burden, though? The defense is arguing that because all you had to do is negate reasonable force, this lessened your burden.
I don't see it that way at all, because in the three elements that are, strictly discussed in case law or that are traditionally discussed, this concept of reasonable force is all through it. There's no way just saying the force wasn't reasonable, that goes towards excessive force. It goes towards, what was the defendant's honest and reasonable belief about what was happening to determine what force was reasonable. And in using excessive force, that's the whole point. You discuss, was the force reasonable in relation to what threat you saw? It does not create a fourth element. To say that, then why isn't the excessive force instruction a fifth element? These are legitimate explanations given by a judge. And that was a very brief mention of the reasonableness. The judge could have gone into much more detail if the judge had chosen. And there is no way that this would have clearly changed the outcome of the case if that one phrase wasn't missing, because the jurors would still, in looking at the three elements, that the counsel has talked about in the cases, the jury had to consider the reasonableness of the defendant's actions, the reasonableness of the defendant's perceived saying what the force would be. This is part and parcel of self-defense. And you can't pull that out and say there should be no discussion about whether the force was reasonable. You're using deadly force here, and there has to be a weighing of why deadly force would be reasonable. It just cannot be pulled out. It doesn't make it an extra element that changed the state's burden of proof. On the second assignment of error, all you have to do is look at this, whether the facts could have related to a sudden, I will say it backwards, under the influence of a sudden passion or a fit of rage. All you have to do is look at the defendant's testimony. He went into great detail about describing that he thought Landacre looked crazy and psychotic in his eyes. He was so angry that he was interfering with this exchange of the child, and he felt he shouldn't have been there. But all you have to do is look at that testimony, and he made that argument.
Was he talking about the victim being angry or himself being angry?
The victim. The defendant.
So what does that have to do with the defendant and his sudden passion or fit of rage?
Because he was saying he was reacting to this man, and he was reacting to someone inserting himself into the situation.
I thought he was saying he was scared of him. I thought he was scared of he was arguing he was scared of the victim because the victim was enraged.
He did, but if you read his testimony, he also was talking about how angry he was. He said, I'm in fear, but at the same time, that was up for the jury to decide. He knew the victim had no weapons at all. And here he is armed with a gun. But in his explanation, you can look at what he stated in his statement to the police, but what he testified at trial, especially, he talked about more than fear. He talked about that his anger at this man having injected himself into his son's life, that he showed up at the scene, he pulls up, he shouldn't have been there. Why did he even come? He definitely laid the groundwork for an argument that he was under a fit of rage or sudden passion.
Well, I mean, counsel's point on this is that it undermined the self-defense because you can't have both states of mind.
But you're not restricted in what you're going to argue. And as the defense evolved and witnesses were cross-examined and the defendant testified and he was cross-examined, I think the facts that were there before the defense counsel definitely could have fit. It says if under any reasonable view of the evidence, the lesser included offense would be appropriate, that must be given. And when you look at his testimony, if you read all of it, it definitely laid the groundwork for that he was under, the jury could have found that he was it was not a purposeful killing, but that he was under a sudden influence of sudden passion or a fit of rage.
Would you agree though, I mean, going along with Judge Zayas's question, that if you're trying to, as a defendant, if you're trying to argue self-defense, it does undermine your defense if your lawyer also says that you were enraged. It doesn't jive. And as a defendant, you should be able to decide if that instruction is going to be given, because it really, they don't go together, do they?
I understand what you're saying about if one is here, but there was no discussion that this defendant said, I want an all or nothing defense. The fact that he rejected a plea at one point is not the same as saying, I have rejected all discussions of any other strategy. And the trial attorney, this was a strategic decision to handle it this way. I mean, he argued in closing, he had two attorneys, and the one argued he was completely justified by self-defense. And they went through all the elements and said this was proven. But then he did want to say, we're here to decide, did the state prove murder? And was he or was he not justified? And then he said, and I think he had a right to strategically to say, but even if for some reason you decide that maybe one element was not made, I'm telling you they were all made. There is self-defense. But if you decide there was something missing, at the very best, it would be manslaughter. So that is a strategic decision on how to handle this. And I think that was very appropriate in this case, given the evidence that came out at trial. Obviously, so for these reasons, I don't believe there was ineffective assistance of counsel at all. I think you received very good counsel. The only other, there was a discussion about that the attorneys should have asked for an instruction on the presumption of self-defense. That if you were in your car and you were attacked, here's our wonderful lighting system. The evidence was not that the victim attacked him while he was in his car or even came towards him arguing. There's no evidence to support that. So that instruction should not have been given. It was not ineffective to not ask for that instruction. And the weight of the evidence, I would just, it's up to the jury to look at both sides, to listen to his statement, the defendant's statement to the police, and what he said at trial. And there was definitely evidence to support the verdict.
Thank you. Thank you for your argument this morning.
Thank you.
Attorney Glaser?
Yes, Your Honor, thank you. Judges, just briefly, the state argues that it was not considered as a fourth element, the reasonable force. I think it's completely clear from the transcript that's exactly how it was used on page 361. To prove beyond a reasonable doubt that self-defense does not apply, the state need only disprove one of the four elements that I just mentioned, the fourth element, and the defendant used reasonable force. So I understand Ms. Lapp's argument that this is deadly force, and so reasonableness is always going to be a consideration. However, by making it an element that can be negated by the state and the self-defense completely goes away, it's lowered the state's burden. Deadly force is contained in the second element. It says that the defendant must believe he's in imminent danger of death or great bodily harm. And it's also defined immediately following the definition, what deadly force means. And again, what excessive force means and disproportionateness. Those are considerations, but they're not something that should just be a win-all if the state can disprove it. And so that's why it lowered the burden for the state. And as far as the Mr. Reimer rejecting a plea, he was clear that he was rejecting a manslaughter. That's in the transcript itself. The defense attorney addressed him himself in the beginning of the case and said, do you wish to plead to a manslaughter? And the state put that offer on the record. And then again, at the close of evidence. So it was very clear that he rejected a manslaughter, not just a plea. I mean, a lot of times in the record, there's just conversation about accepting a plea or going to trial. But he was clear about rejecting the manslaughter plea, even though it was pursued. And with that, judges, I'll submit on the brief. Thank you.
Okay, so unless there's any other questions, thank you both for your arguments this morning. we will take the matter under submission and issue a timely decision. And we wish you a wonderful